paragraph by the order dated in the order dated November 21, 2024, the submission of Mr. Sengupta that the proceedings before the ICC shall be concluded by the end of December 2024 was placed on record. Full stop. Petitioner is participating in the proceeding. The learned advocate appearing for the petitioner submits that the petitioner is participating in the proceedings before the ICC. First up, in view thereof, nothing survives to be decided in this writ petition. The writ petition accordingly stands disposed of by directing the authorities to conclude the proceedings before the ICC as expeditiously as possible, but positively by the end of December 2024.
My lord, after conclusion the proceeding, my lord, the sub of the order of the
That has to be,
That is a procedure.
that they will do.
get
Conclude the proceedings and take all consequential steps thereupon.
That is what I was indicating.
ঠিক আছে?
Kindly
To
will
conclude the proceedings by
Yes.
the end of December 2024 and to take all consequential steps thereupon.
it can be go anywhere around. Yes.
You invited this,
Yes, invited.
you invited this. Yes, next. 4.
Color of fund money has not been seen.
I beg to apologize, my
Color
lord.
of money has not been seen by us.
For a month, I couldn't come to court because of my illness, my lord. For my illness, I couldn't come to court, my lord. Practically, my junior is at the wheel.
Well, now what do you want?
This for the state.
I'm for the state.
Yes, state has to give those.
Obviously.
That order money has already passed.
Yes. Now,
Now he cannot say that recalling of this.
yes, when that will be done?
Yes, proceed.
He petitioner raised the bill before the Kishannagar municipality. And possibly lodging.
That has been done. Now your written recommendation is necessary.
Certified given that work has been successfully completed.
Yes.
Yes.
What a time, what a time.
Order was passed on 12th of November.
Yes, Lord.
At a time now. এর মধ্যে টাকা দিয়ে
Lordship, there are so many.
Balurghat and Krishnanagar. No, Ranaghat and Krishnanagar.
This is my lord JBC. GBC.
GBC.
No, GBC
506, my lord, looking.
24506.
I have handed over to your lordship one. In terms of your lordship direction.
Admitted dues.
All admitted dues, page has been indicated.
Yes.
The supply is to my lord friends also. Municipality wise, Kishannagar municipality,
Krishnanagar.
then my lord Ranaghat and Balurghat.
Ranaghat, nobody is appearing.
We have given notice as per your lordship direction.
Yes.
These are municipality. These are municipality.
For which municipality?
No.
Krishnanagar. Yes.
My lord, what should I say? This is my lord notice by email. So your lordship will accept that or not, I don't.
Received.
How can I know? It has been sent. Sometimes I have been heard. It is go to spam box. I don't know what is that. So it is not received.
You have to file a affidavit of
Yes,
service.
that's why I cannot file this unless it is served personally or by speed post. As
No,
per the-
email service is also accepted, but you have to state that it has been served.
How can
That
say?
responsibility you have to take.
Person can say it is sent.
No,
Is
I
it
think some
procedure?
delivered some,
Whether the
Procedure.
mail has been delivered
Now,
or not.
at least once it
Particular
happened
site-
with me, somebody said, I have sent you a message. I don't know, I asked my daughter to find out where did it is. He absolutely fine, it's gone to spam box.
yes, yes.
So,
No.
nobody looks in the spam box. This fault, service is faulty, according to me. Well, as per the civil procedure code, this service through email is totally faulty. What the court will presume? But it has been sent, my lord, it is with me.
Sending is, that means you have complied with the directions,
Yes. That
only to that,
much, yes.
nothing more than that.
I cannot say anything. I am appealing for a client also.
All right, let us proceed with the other municipalities for the present. Krishnanagar,
First, Kishanagar
yes, Krishnanagar.
has already said he has nothing to say.
Acharji, you are appearing for Krishnanagar.
Yes.
Come this side.
Is it Keshava? Acharji.
My lord, if your lordship kindly have a look at page 56 of the writ petition.
5-6.
My specific instruction is this, my lord. I have not received any bill from the ME department.
Yes,
I have that instruction.
yes, correct. He already submitted. No recommendation received by.
Recommendation. They have
Unless the,
submitted the bills,
unless the recommendation is.
that will be with the state. There is no dispute with regard to the claim.
So far as the claim is concerned, whatever claim against the municipality, we have forwarded to the ME department. Now the ME department will, my lord.
Show me the claim with regard to Krishnanagar, page
Yes.
56 you said.
Yes, my lord, 56, he has referring.
Compliance. Successful compliance. These are. Up to 7.
So this is the certificate, Mr. Basu, I think you have indicated in the chart that, where is that?
56.
Well, kindly come to para 17 of the writ petition. Page 12. And what?
Yes,
What
so
This
two items. One is third and fourth RA bill.
Krishnanagar is first and the supplementary bill for.
Yes, third and fourth
859.
RA bill. So withheld amount is, এটা কি?
Your lordship will
Crores or lakhs? Mr. Basu?
crores.
Crores.
Difficult for us, I know. For my landed fee is the problem.
Yes, and the supplementary bill for extra pipeline is, that is also crores.
And you
Yes.
will get these two pages, page 55 and page 75. You will get the certificate.
Yes, state. What have you done with this?
My lord, pausing for a moment, kindly have a look, page 73 of the. writ petition.
73.
Yes. My lord, this is the bill raised by the petitioner before the superintendent engineer. This is in respect of the supplementary bill.
Yes.
If it is the certificate, then turn over the page and you will find actually executed the work. That is.
Oh, I am not on that. It is said supplementary bill for carrying out extra length of
Yes.
raw water. Therefore, the supplementary bill which has been sent by the executive from executive engineer to superintendent engineer. Therefore, municipality has not been given anything. It is in between the, my lord, executive engineer and the superintending engineer.
Yes, now they have to give this recommendation.
Yes, that's true.
Yes, I'm asking the state.
Lordship, as per my instruction is concerned,
আমি তো
Up
বলে
to-
দিয়েছি এর আগে।
10th
তুমি
RA
পয়সা
bill
পাচ্ছ, আমি
has been
পয়সা
recommended.
No, kindly come to page 12 of the writ petition.
Yes, Lord.
Let us proceed one by one item. With
Third
regard
and
to Krishnanagar, there are two items. These are the two disputed bills. One is third and fourth RA bill,
Yes.
and another is supplementary bill for extra pipeline work. Have you sanctioned this or have you recommended this?
Lordship, supplementary-
According to you, up to 10th you have recommended.
Yes, Lord.
So 10th covers third and fourth.
Yes. Payment has been made, Lordship, third and fourth RA.
Payment has been made.
Yes.
You
Much
have not-
earlier, that's
you
why
have not paid.
the 10th and 9th RA bill has come.
Can you show that with regard to this third and fourth, you have made recommendation? Payment will be made by the municipality.
They will not pay.
If you say I shall record, yes, you have recommended, I will direct them to pay. I shall record your submission that recommendation has been made.
My lord, so far my instruction is this. My lord, I have out of my lord, 20 crore, 22 lakh 79,994 we have paid.
No.
No. Oh, no, 20. Yes.
No,
out
that
of
is,
21
Mr.
crore.
Acharya, that will be a difficult thing. Because Mr. Basu's client is not claiming with regard to the others. Dispute is with regard to third and fourth RA bill, another is supplementary. So if you say I have paid this much, we cannot tally with that. You have to say that with
Third
regard
and
to third, fourth, paid, supplementary
My
paid.
lord, kindly have a look. My lord, my report. My lord, I have filed. My lord,
Third and fourth, have you paid?
my lord, kindly
Show me
have
the
a
document that
my-
you have paid with regard to
My lord,
third and fourth.
this is the chart, my lord. Kindly see. That is, my lord, with your lordship's record also. Your lordship directed
And
to file.
payment has been received, Lord. Record রয়েছে। That's why 9th and 10th RA bill has come. Forward.
No, this is, Mr. Acharya, this is the bill value. Bill value means paid.
Yes, out of 20,
Show it to
out
Mr.
of 21 crore, my lord, 20 crore has been paid.
See, kindly see the payment has been.
Mr. Basu, kindly see this.
Will not kindly see, kindly come to 64 to 66. All documents has been annexed. Kindly come 62, not 61, 62.
Mr. Basu, all these are factual things, paid, not. How can the read court decide on that?
Decided.
He is saying this has been paid.
Koti আছে? দেখা না।
Lordship, payment has been received. Kindly see the, see the client is received.
Payment of what amount?
Third and fourth.
Kindly come to page 62. You will get
60?
2. Kindly come to the left hand side. Third RA bill, serial number of bill number, third RA bill. Kindly come to 62 at the top bottom left hand side. Top.
Top, third RA bill, yes.
Let them show this bill has been paid. My lord may be satisfied. And next is 4th.
Next page.
No, 64. 4th RA.
Mr. Basu, what is the total amount?
Can you come to 63 last?
63.
66 last. At the bottom, we have also said what has been paid, and what has been withheld, that has been indicated.
21 এর মধ্যে 20 paid.
No, withheld, how can I ascertain from this document? No.
This is not my document. Kindly come to the bottom, 66 bottom.
Lordship, we said only the extra work
Kindly
which
come.
he has done.
66.
So my lord has find these are the 2 RA bills we are claiming. Kindly
Yes.
see quantum of total due here.
66, bottom.
First of all,
Yes.
extreme right hand column. Above column handwritten, you will also find those are the claims.
Yes.
And 75 such and such is paid. Rest is due.
This is with regard to fourth.
Third and fourth combined.
Where do I find third and fourth combined? Because this says gross value of fourth bill.
No, these are the 2. These are the
No,
2.
space 66.
One, 66,
Mr. Basu, kindly come to page 66.
one.
Last, yes, it says gross value of fourth
Fourth
RA,
RA.
not third and fourth.
Third and fourth.
No, no.
Then they will be paying more to me.
But here it says fourth. That is why I'm asking you.
Bottom is third. I have a note. 19. Excellent. 19. 1 crore 19. 91. As Manoj can
1 crore 91.
and bottom is 1 crore 65. That is third RA bill.
My lord, may I explain? These two amounts which your lordship add, it comes to 1 crore 91 lakh. That is what I have claimed. Total amount deducted 1 crore 91 and then 11. These two which your lordship adds, which comes to 1
That
crore
figure.
91, which I have taken in the chart.
Yes.
This is the amount withheld from these two bills.
There is no disputed question of fact.
And they have certified up to 7, all work done.
Work done, certificate is there. No problem.
Yes. Mr. Acharya, this amount, according to this is your chart, page 66.
Their document.
Kindly come
No,
to
no, no,
this.
this is not my chart. 66 not my chart.
Bill.
This is the bill. Out of that, this has been
Who said
the amount which you have paid. That has been deducted. This is the balance
Well,
amount.
I have paid, my lord, on the basis of the recommendation of the ME department.
Yes.
Now, whatever is there. This bill is for, my lord.
Where is the recommendation with regard to third and fourth?
Third and fourth.
Show me the recommendation with regard to third
At
and
the bottom, at the bottom. Joint Engineer Civil, Nodia Division.
Yes,
They certified work done and this is the bill amount.
yes.
Now.
So show me
payment.
what was the recommendation and how much you have paid out of this? Because a part has been withheld.
That have said, what have we paid, we have said.
It's not, Mr. Acharya, it's not the case of the petitioners that the entire amount is lying due.
That's why give it a chance.
With regard
I
to
have
third
also
and-
not said, out of 21 crores, my lord, 20 crores has been paid.
Out of
21, my lord, if your lordship kindly see the chart.
total is 21.
21,
Where do I find that 21?
this chart is there.
Chart is ballot reflection.
This chart is 20.
No, that out of 21, 20 paid. Now, if my learned senior friend, my lord, disputing this bill, then I have to,
disputing.
I am then, my lord, I have to file an affidavit there to that effect.
No, he's already.
Mr. Acharya, not a question.
No,
of-
no, I have not filed any affidavit, only a report was called for.
That's
Not a question of filing the affidavit. The bill's total amount is there. As against the respective bills, you give how much you have paid. It will come.
My lord, kindly have, my lord.
What is the basis of this, your chart? That
Yes,
is-
then my lord, I have to take instruction and I shall come back.
No, this
Yes.
is, Mr. Basu, this chart, kindly take up this.
Now,
What is the-
therefore,
what is
you-
the basis
my
of
lord,
this chart?
therefore, he is
No,
disputing
he-
this.
He is saying, I don't think Mr. Basu will also dispute this because according to them, these are the payments which they have made
I also accept.
against those bills.
This is the bill I have.
Kindly check up whether with regard to third and
Third.
fourth, whether that is correct or not.
The recommendations of the third are, can you see?
Yes. The amount has been mentioned.
Yeah.
Yes.
Can you see the recommendation?
Third and fourth.
Third and 14 years.
Then,
Yes, I think this is
Total.
then, my lord, it has been paid.
Lordship, this is the fourth.
no, this is the running account bill. Where is the recommendation? This is the recommendation.
Last page, this is the recommendation.
The handwritten. This is not legible. What was the recommendation?
Payment account. What is the, let them show to lordship, my lord, what is the payment? This is the
Mr.
bill.
Basu, kindly see
the
these
bill.
recommendations. I cannot read that. Let them give a legible copy. No.
Can read that, I can read, an old man.
My lord, this is said, my lord, payment
No,
already made by
Give a better
Kishanagor
copy. Where is the better copy?
Next date, Lordship, I will provide the better copy. Lordship. This is
No, my lord, if you,
only the department has supplied.
No, maybe, but because they have to see, because according to you, you have recommended.
Yes.
So it has to be seen whether the amount entire has been recommended.
Execution certified, now recommendation and payment.
Yes.
The payment has
So
been paid.
he has claimed X amount. So it is to be only seen whether X amount has been recommended or X minus something has been recommended.
no, my lord,
So that has to be seen.
Yes.
So if X minus something has been recommended, then the dispute what for that recommendation has not come, that is to be seen. So this is with regard to Krishnanagar.
Krishna.
my lord,
Balurghat,
only thing, my lord, only thing submit. My lord, I have filed a
Second
report
one,
that is with my,
Supplementary bill, inclusive.
my-
a supplementary bill. What happened to supplementary?
Supplementary bill totally depends upon the municipality, not raised
Kothay?
raised before the.
Execution I have given.
Yes, Mr. Acharya, supplementary bill.
My
This
lord,
your
kindly-
chart does not say anything with regard to supplementary bill.
Coming.
I think that chart I have given.
My lord, kindly see
I have
page
handed over to you. This is
73.
the chart.
73. Page 73,
73.
my lord.
Execution. আবারও দেখাচ্ছিস কি? আরে admitted.
Subject supplementary bill for carrying out extra length of
Volta?
raw material.
Yes.
Fulton executed.
Hmm.
Executed. He has done. Next page. It may be concluded agency has actually executed the work.
Certificate of execution.
In the supplementary bill submitted by the concerned agency.
Yes,
Submitted for your kind consideration if found acceptable and necessary action.
so you have
Who has-
done your job.
Who has this? This is executive engineer. He said if not,
He
therefore I have
is
no stake
He's
at all.
he's certifying that the
Yes.
work has been done.
Work has been done.
So what more is required? What more is required for release of payment?
But that is the Department of ME.
No, they are certifying this.
They are, what is the next page? In
Next.
view of the above facts and circumstances, it may be concluded
Yes,
that the agency has actually executed the work
Stop.
as indicated in the supplementary bill submitted by the concerned agency.
Yes.
Submitted for your kind consideration. Therefore, it has been submitted
Kind-
with the executive engineer.
After execution.
Mr. Acharya, kindly come to page 74. Executive engineer is certifying this. He is sending to the superintending engineer
Yes, yes,
of the municipal engineering department.
yes.
So now the municipal engineering
Yes.
department has to
Recommend.
give their recommendation.
Page 75, superintending
হ্যাঁ,
engineer.
দেখি সব দেখানো আছে। আর বলা লাস্ট লাইন
Yes, next page
75.
75. Superintending engineer is writing to the chief engineer.
আর কি রইল?
Yes, you are saying.
So what remains?
Not if I shall take instruction.
কিসের ইনস্ট্রাকশন এই তো মহা
And third and fourth, what is
I
the
will
recommendation? Let me proceed part by part.
recommended. I want your lordship.
But so far, third and fourth, I have paid, my lord, the amount is tallying with my
Uh,
card.
Telling. Payment not telling. Bill telling. Bill value is telling, not payment.
Mr. Basu Lanet, senior
Then, my lord, I am
representing-
denying this submission.
representing the petitioner
Payment
draws
account
the
payment
attention
already
of the court
পাইনি কি
to
করে? আর মুশকিল নেগেটিভ কি করে দেখাবো?
draws the attention of the court, submits that
আগেরগুলো পেলে না,
Bill
পরেরগুলো
value.
পেয়ে
the supplementary, Mr. Basu, kindly hear this, submits that the supplementary bill for extra pipeline work submitted before the municipality. না কি বললাম, the payment in respect করে, payment in respect of the supplementary bill for extra pipeline submitted by the petitioner before the municipal authority has not been honored till date. In respect of Krishnanagar municipality code.
Make it fully on. Supplementary bill or 3 and 4?
No, let me proceed stage by stage. Let me proceed stage by stage. Supplementary, I'm on supplementary path.
Then not paid at all.
Uh, from
লিখি দেন তাহলে লিখি দেবো ভাউচার নিয়ে উপরে দিন
it appears from the records that the chairperson, Board of Administrators, Krishnanagar Municipality,
নাও দ্য চেয়ারম্যান
No, my lord,
forwarded the supplementary bill
মুখে দেয়া আছে।
to the Executive Engineer Nodia Division, Municipal Engineering Directorate, under a covering letter dated January 21, 2022, requesting the said authority to take necessary action for approval of the said bill from the competent authority. It further appears from the record that the executive engineer, Nodia Department, has concluded that the agency has actually executed the work as indicated in the supplementary bill submitted by the concerned agency, কি বললাম the executive engineer
মানে সবার
by
কথা সে দিয়ে দিল।
by a later dated
তারপরে এটা বল খাওয়া।
no, by a later and communicated such fact to the superintending engineer within bracket East Circle bracket close Municipal Engineering Department by a later dated March 16, 2022. First up, the superintending engineer in its turn by a letter dated 12th of May 2022 addressed the chief engineer, Municipal Engineering Department that the quantities as expressed in the letter by the concerned executive engineer have been actually executed by the agency at site. It's a paragraph. Mr. Basu Lanet, Senior Counsel, assisted by Mr. Shane Lanet, Senior Counsel, submits that in spite of the fact that the concerned authorities of the Municipal Engineering Department have certified that the agency has, that the writ petitioner agency has performed the job assigned to such agency as indicated in the supplementary bill, but no payment against such bill has been released in favor of the petitioner agency till date. First up, from the aforesaid documents, this court is of the considered view that the authorities of the competent authorities of the Municipal Engineering Department
কিছু শব্দ হলে দাঁড়িয়ে
arrive at an opinion that the writ petitioner agency has executed the job indicated in the supplementary bill. Full stop. Paragraph. Mr. Acharya Lanet, advocate appearing for the municipality submits
কৃষ্ণনগর মিউনিসিপালিটি, not the other municipality.
Krishnanagar municipality submits that unless the authorities of the Municipal Engineering Department gives a written recommendation, issues a written recommendation to the municipality to release the payment cannot be made to the petitioner.
Another submission was so far as the third and fourth.
I'm coming, and now I'm on the supplementary. Don't mix all these. First up, in view thereof, who shall issue a recommendation? The competent authority of the Municipal Engineering Department. I think the chief engineer was directed. Accordingly, the chief engineer, Municipal Engineering Department, being the second respondent, is directed to issue written recommendation to the in view of the above. In view of the above, the chief engineer such and such, being the second respondent, is directed to issue the written recommendation to the municipality, to the Krishnanagar municipality, for releasing the payment on account of the supplementary bill for extra pipeline work as indicated in the tabular statement under paragraph 17, in paragraph 17 under serial number 1B of the tabular chart. First up, paragraph, insofar as the claim of the petitioner for কি বললাম written recommendation টা বলেছি না, সেটা টাইমটা বলিনি না, within a period of 2 weeks from the date of receipt of a server copy of this order. Full stop. Immediately upon receipt of the said written recommendation, the chairman or chairperson, the chairman of Krishnanagar Municipality, which respondent? The fourth respondent is directed to release the payment on account of supplementary bill for extra pipeline work within a period of 2 weeks thereafter. ঠিক আছে এটা next হচ্ছে লিখুন insofar as the claim of the petitioner against third and fourth RA bill pertaining to Krishnanagar Municipality, the learned advocate appearing for the state submits that recommendation for payment against third and fourth RA bill has already been made. First up, the learned advocate produces a document before this court. First up, however, the said document is not legible. First up, the learned advocate for the state prays for an accommodation to produce a legible copy of the same on the next date of hearing. The learned advocate for the state is further directed to supply a legible copy of the recommendation for payment in respect of third and fourth RA bill pertaining to Krishnanagar intake jetty to the learned advocate on record of the petitioner. When? How soon?
Within a week.
Within a week from date.
My submission may be recorded, my lord.
For what?
So far as third and fourth bill is concerned, I have given the chart that has been paid, payment has been made.
Entire.
Third and fourth. Third and fourth. I
Mr.
said, my lord, out of
Mr.
21.
Mr. Acharya, learned advocate, appearing for the Krishnanagar Municipality submits that the entire entire bill amount in respect of third and fourth RA bill has been paid to the petitioner. Such submission is however disputed by Mr. Shane, learned senior counsel representing the petitioner. First up, the said issue shall be decided after the state produces the legible copy of the written recommendation on the next date. Let us proceed part by part, otherwise we will not get anything. Yes, next, Ranaghat. Ranaghat,
Lord, Ranaghat has not been served so far. Mr. Basu has submitted.
he has sent, all right, all right, let us, what happened to Balurghat?
Order with your lordship, dated 12 November. Your state was supposed to take instruction. Kindly have a-
Yes, what is your instruction?
Release of security deposit. His lordship has clarified.
My lord,
Yes,
my lord, kindly excuse me, my lord. May I take leave, my lord? Subject
Yes,
to
yes.
your lordship.
your part finished.
First paragraph of the order. Lordship has summarized.
First two paragraphs.
State, your lordship was not satisfied with the explanation, directed state to
Lordship,
instruction.
regarding the payment, Lordship, can you see the report? Lordship?
No, with regard to the release of security deposit, Balurghat security deposit.
But I am representing. He-
No, you are for the state.
Yes, Lord.
State, what is your instruction with regard to Balurghat? Balurghat, what is your instruction with regard?
Completed.
At present, no.
Deposit.
At present, is not. Lordship, regarding the security deposit, depends upon the, so many criteria are there, Lordship.
No criteria, everything done, it has been decided. Have you gone through this order?
Probably not. They can order this. সব decide হয়ে গেছে।
Security deposit.
হ্যাঁ,
You have, but the order is there. Mr. Sen, why the entire copy of the entire portion of the order is not here? Is it not coming in the from the website?
probably it's our fault.
No, kindly check up, but if it is not properly uploaded, then we have to upload that. Something is missing from the
ওই তো আছে।
first page,
It again.
First page, 1 or 2 lines may be missing.
By fifty one time is
Nothing from the server. Server I've seen. Insofar as Balurghat municipality is concerned, the learned advocate for the state seeks an accommodation to take instructions. ঠিক আছে? তারপরে লিখুন, Mr. Basu, learned advocate appearing for the petitioner, submits that a notice has been sent through electronic mail to the
Municipality itself.
Ranaghat.
to the Ranaghat municipality. Stop. Mr. Basu, comma, in his usual fairness, comma, submits that he has no documents to show that the order
Communication was
has been
served.
communicated. In his usual fairness, submits that he is not in a position to submit that the municipality is aware of the date of hearing. First up, in view thereof, the learned advocate on record of the petitioner is directed to serve it by speed post.
That will be better.
Is directed to serve a notice upon the chairperson, chairman, municipality who have implemented, no, only the chairman.
Not in my hand.
Mr. Basu
I have
and
to
Mr.
check.
Sen, both of you are appearing in a matter. Cannot say it's
No,
not in your
I'm
hand.
not saying. Entire blame is on
Both,
me.
both
Not
of
me. Yes.
you are appearing.
Yes. After this matter, I will give an instance. Yesterday happened. Can you
আচ্ছা
dictate
কি
it?
বললাম? Is directed to serve a notice upon the chairman, Ranaghat municipality, intimating the next date of hearing. আচ্ছা কি বললাম? Serve a copy by speed post with acknowledgement.
And also direct us to communicate the orders already passed by my.
First up, the learned advocate on record of the petitioner shall be obliged to communicate the previous orders passed by this court in connection with this writ petition, insofar as Ranaghat municipality is concerned. 2 weeks after that recommendation, so let me keep it after 2 weeks. Something will come.
But our previous order is not yet complied. The other matter.
That is a different matter. So far as
No,
this
but
supplementary recommendation,
same color of the money you have not seen.
this matter after 2 weeks under the same heading. তো 2 সপ্তাহ পরে একটা ডেট দিয়ে দিন।
এই chart একটা আমার copy তে কোথায় গেল? Yesterday,
Basu, take this.
this one.
That's-
Acharya dilo, Acharya. No, this one no.
No, that is the
Acharya what has been handed over? That chart. Acharya. Yesterday what happened, my lord?
এটা ফেরত দিয়ে দিন। Yes, yes, Mr. Basu.
Yesterday what happened? A contested appeal with the leave of the court without certificate can be filed. Thereafter, so many orders passed, everything. 5 days, Justice Devanshu was hard for 5 days. Dictated the order for 45 minutes, allowing my appeal. It appears, my lord, the certified copy has not been filed. Taken on June. Just thrown out the file, everything goes. I got this certified copy from the advocate on records brief. I see. This is called luck.
Order recalled.
Everything. I am saved. I have not been scolded. You are so favorable that he has even forgot to scold me also.
Yes, call the next matter.
8.
দেখি। None appears for the petitioner. So for the ends of justice, the hearing of the matter stands adjourned for the day. Next.
Eleven.
Yes.
Our case is that, my lordship, there is an order of this honorable court, wherefrom it appears that it was directed to issue 9393 notice. But on that score, they issued notice, subsequent notice asking for us to take the award. We accepted the award with objection. And the question arose whether the notice of award was served upon us or not, because the limitation, we cannot approach the reference under section 18 unless I get the information either from the date of the award or from the date of the knowledge. But here is the situation is neither of it. 18 to neither A nor B. But neither the award at the time passing of the award I was there, nor, my lord, any notice under section 12(2) was served upon us. On that score, my lord was looking for whether there is any specific averment to that extent that section 12(2) notice was given or not. But in the writ petition, we have stated that the compliance was not done as per the statute. My lord, paragraph 35, thereafter 38 and 40. 35, the petition states that in the event award was validly passed on March 97, in that event, your petitioners ought to have been given opportunity to challenge the said award, which opportunity has been denied to the petitioner by reason of the fact that the purported award has been disclosed after 15 years from the date of the alleged passing, therefore, is sought to be barred by limitation. Thereafter, paragraph 38 of the writ petition at page 25, by reason of such action on the part of the respondents, your petitioner have been deprived of filing a reference petition challenging the compensation under the award section 8(2). Thereafter, paragraph 40, that assuming that if the aforesaid award was genuinely passed by the respondent on 31st March 97, why the respondent did not allow the petitioners an opportunity to challenge the award within the time period provided under the statute. The action of the respondents therefore suggests that no award was validly passed and therefore bad in law and arbitrary. But these were the averments in support of 12(2) notice was not served. Though the language of 12(2) was not given, but the letter and spirit of the statute is that the opportunity whether was given or not, but that letter and spirit of the statute was given. My lord, kindly in our reply, my lord, kindly takes our reply once, affidavit in reply. In our reply, my lord, page 6, subparagraph T, page 6, my lord. Page 6, it is under 5T. That the copy of the award was not annexed to this affidavit in opposition filed by the respondent. In absence of a copy of the award, it is not possible to verify that the award was passed within the time or not, and the competent authority was not approved or not. The respondent further did not serve any notice of the award, which is also very vital for proper adjudication of the present case. So they had the knowledge that we have taken this point. They didn't use any rejoinder to this. But not only that, my lord, in the writ petition also, my lord, while they responded to our, my lord, the order, while they were responding to the earlier order of this honorable court, my lord, their stand is that we have been asked to appear. That is at page 78, 79. Nowhere they have taken the point where when the writ petition was communicated at page 77, that they were required to ask to act in a certain manner, and 12(2) was also taken as a point. Page 77, my lord, kindly comes page P8, page 77 P8. There also toward middle of that paragraph, my lord, section 12(2) was, my lord, referred at, and the order indicating that 93A, 93B. Had it been the case that they were not represented or did not take the point before the learned court, before this honorable court on a prior occasion. But they ought to have come up with a case that no, this is not the case, or this order required to be verified. But that point was never taken. So our case was accepted to be true by their subsequent action. So in that view of the matter, we have been
So
deprived of
your case was accepted to be true? What
my-
case of yours?
that the order passed by this honorable court,
Yes.
my lord, page 73, the order of Justice or Jayantakumar Bishwas, that they need to start proceedings under 9.3, 9.3a, my lord, page 74, my lord. For these reasons, I dispose of the writ petition ordering as follows: within a fortnight from the date of communication of this order, the collector shall issue the requisite notice under section 9.3a or 9.3b, as the case may be, of the Land Acquisition Act as amended, such and such. Such notice shall be given to the person such and such. So there is a vivid description has been given, and also thereafter towards end, requisite section 12.2 and 31 notice shall also be issued to the persons concerned immediately. There the requiring body does not make any fund of required payment, such and such, there is no order as to course. But in view of that, the order was communicated to the concerned authorities, my lord. Page 76, 77. But they did not take any point regarding that, no, it is not required, or award has already been passed, so the order is required to be modified. So they need to go to this honorable court further. Rather, my lord, there are some suspicion, my lord, there are some signatures. My learned advocate record is insisting, my lord, it shows that something has happened subsequently. So, my lord, I have been deprived of the opportunity to challenge the award because the notice was never served 12.2, neither I was present. So 18.2 has not been complied. So, my lord, and the money we have taken in March, end of March 2012, and we approached this honorable court in May 2012. So, my lord, the time given in the, my lord, 18.1, my lord, kindly takes up the act once, my lord has not. 18, my lord, the proviso, first proviso A, it says the 6 weeks. That is from the date of the collector of the award. And in other cases, it is 6 weeks from the receipt of the notice from the, or within 6 months from the date of the collector's award, whichever period first expire. So there is, my lord, difference in proviso A than that of proviso B. A larger time is provided in, my lord, in proviso B. So that after knowledge of, my lord, 12.
Which section you are placing?
My lord, it is, my lord, section 18.2, proviso, under the proviso A and B. May I hand up a copy of it?
No. I have
Mal. So if the acceptance of the award is taken to be our knowledge of the award in March 2012, then also the writ petition was filed within period, my lord, and the matter is pending.
What does proviso B mean?
In
Small b.
my lord, in other cases, my lord, first is regarding, my lord, the knowledge.
If you was present.
You are present, is not
So
the case.
you fall within B.
B.
According to you, you are not present.
I was not present. In other cases, within 6 weeks of the receipt of the notice of the collector under section 12, subsection 2, my lord,
Then is very next part.
or within 6 months from the date of the collector award, whichever period first award.
Shall first expire. What is the meaning of this? This disjunctive or and first.
My lord, if a person, the purpose of this section.
May I take over from my lord?
May I yield to my lord?
Yes, my lord. My lord, he has shown the two subsections, two provisos of section 18. the concept in a land acquisition matter, as your lordship is well aware of, but your lordship has passed several judgments, that it's a beneficial thing so far as the public is concerned. Now, the state cannot, at its whims and fancies, deprive a citizen of his right to at least go and challenge the award. He may succeed or he may not succeed. Now, there have been several judgments which your lordship is also well aware, in which even if the Section 18 application has not been filed for reasons which may be also attributable directly to the land users, yet the court has been benevolent enough to give the benefit of the challenge under Section 18, challenging the award to a land user. In the event the court is satisfied that the land user did not try to squash the delay on the state government for his own default. In our case, your lordship can appreciate two things. One, a writ petition was filed way back in 2007. At that point of time, it was never said that the award has already been passed. But 2007, and they say that the award has been passed in 1997, 10 years. For 10 years, the state does not come forward with a application for recalling of either of the order or for appeal of the order saying, no, we have already passed the award, you have missed your bus. Rather, you give a notice in 2012 under Section 11 and Section 31 saying now you come and correct the award. So, we go, naturally, people in the unfortunate areas, they are not well aware of whatever happens when made receive the payment under protest, and they came and they filed this writ petition. Now, in the writ petition, what is the prayer in the writ petition? One, a prayer for ensuring that we be given an opportunity to file our application under Section 18. Your lordship must see that all that we had sought for. Had this court had been pleased to hear the matter and dispose of it way back in 2012, when the writ petition was moved, at that time we wouldn't have waited for another 12 years. Neither would the state. But and then my next issue was in the writ petition that despite a particular quantum of land being acquired, assuming the acquired, they have taken much more land than what is going to be taken over. So we are also playing a double player that let a survey be made according to our survey, which have arranged the writ petition. They have taken more than double the land which they have sought to acquire under the notification. So all this was order which could have been passed by the court, but I am not blaming the court, not because obviously state had to have an opportunity to hear. Now today in the position, admittedly, the state has failed to prove even to the conscience of the court that the award was passed. I can take two primary points. One is a question of fraud. I'm not going to go do that. Because if I say that the award was not passed in 1997, despite the subsequent writ petition being filed, and this fact not being brought to the notice of the court, then it's a question of going to the disputed question of fact. So I will not venture to go to that aspect of the matter.
So now you want that you may be permitted to file an application under Section 18.
18 and also make a survey of the land which has actually been taken possession of, so that I can claim for either for compensation or for further acquisition of the land. The benefit of that under the new act.
Mr. Kundu, that is with regard to the other lands which do not form part of that notification.
Yes.
So for that, Mr. Kundu, you are at liberty to take steps.
No. I made a prayer in the writ petition itself for a survey. Your lordship sees. Prayer H is also there, your lordships.
Prayer
H. There are two main brands, my lord.
If my lord, if my lord will consider it.
No, where is your statement with regard to what is the excess land?
Yes, my lord, page paragraph 9, your lordship, see in the writ petition.
Paragraph 9.
Page 10.
Yes. And they have not denied this thing. Your lordship will see the affidavit number, my learned junior will show it to your lordships.
ওটা বের করো প্যারা 9টা কিভাবে ডিল করেছিল 20 এটা কোনটা এটা তো
Which is your plot or which was your plot?
My Mr.
yes my lord my lord, it is my lord paragraph 2 my lord
Yes.
annexure P1 my lord mutation certificate was given my lord.
You have not mentioned which are the plots.
We are referred to P1 my lord, that is the mutation certificates my lord.
You have not given what is the quantum, which plots, nothing. You have annexed only those.
And we have only mentioned the area.
No,
The area is
where is
not.
the notification? Where is the notification? Which portion was requisitioned and acquired? Where is that notification?
My lord, kindly comes to page 57 annexure P2.
57, yes. These are the plots.
Yes.
So, what is your claim? In which plot excess amount has been, possession has been taken? No specific averment has been made.
But we had made a survey. Later on, not.
Survey that is.
No, I'm not asking the court to rely on my survey. I'm not asking the court to rely on my survey. I'm not at all.
My lord,
I'm
it's
only saying that I'm only made a survey only to satisfy my client's concerns that the land has been taken by soul. A physical look into the area will itself show that what is 3 acres of land and what is 2 acres of land, or what is 6 acres of land and what is 12 acres or 13 acres.
may I add on my lord? My lord, it's a tea garden. It's not a general plot like other plots which can be differentiated by
But you have to
measurement.
make out a specific case. This was my, I was the owner of such and such quantum. Notification says a lesser quantum, but utilized the entire part of that.
My lord,
This
that,
positive case you have to make
my lord,
out in the
that is made
petition.
out, my lord, kindly see. Annexure P1 shows the plot owned by the petitioner.
No,
Annexure
you have
P2
to
shows,
say in which plot excess amount possession has been taken.
my lord, the plot in its entirety is a tea garden. It is very difficult to, unless a surveyor is appointed and an expert is appointed, it is very difficult to point it out. It's in
At my
entire-
cost, remember, at my cost, if I may at least beseech your lordship that at my cost.
What
the
were it
state-
when possession was taken? When the
but-
possession was taken, you ought to have challenged at that point of time.
my lord, with respect, my lord,
When
It
possession was
was shown.
taken,
my lord, your lordship is well aware, my lord, a tea garden is an area where, my lord, it's very difficult to actually measure
possession-
the area in question, my lord, and
Question
and-
notice. Question notice nahi.
and your lordship will see that the affidavit in opposition also does not. Affidavit in opposition does not. Affidavit in opposition to. Pregam 9 উত্তর দেয়, pregam 9 উত্তরটা। 9
Yes. Yes, anything more, Mr. Kundu?
Lord, I am only making this prayer, Lord. If your lordship once again shows me to the dungeons for the measurement, if I have a measurement done, I will know. Then I will come before your lordship once again a fresh petition that the land has been accomplished. I can't be as a citizen be deprived of my land without any
All right.
compensation.
Anything more?
No, I cannot say anything.
Yes, Mr. Kundu.
Only one thing, my lord. My lord, regarding the second part of the proviso of section 18, my lord, there is a judgment of the Honorable Supreme Court. My lord, I have only one copy, my lord, that is
Yes, yes.
also in
You
a
can
rough.
place, you can then hand up.
I can, my lord, my lord, it is, my lord, 2005 page 431, my lord.
Yes.
Here, my lord, where, my lord, the other part of the 6 months from the date,
2005,
my lord, 2005-7 SCC, page 431. here the limitation of second proviso, it has been High Court rejected, though the reference court allowed. Subsequently, Supreme Court rejected, set aside the order of the High Court and said, no, this limitation is a beneficial one, what my learned senior friend submitted. So it is to be construed that from the date of the knowledge of the award only. With the course of the day, I'll make a fresh copy and I'll submit one.
Have you filed any application under section 18?
No, I couldn't. But within time, we approached this honorable court, my lord. I knew that my lord will take up that point. My lord, there, my lord, application was filed.
Because
There, my lord, but
it's not,
that will not stand in the way interpreting the latter part of the proviso B. My respectful submission, but the letter and spirit of that particular provision has been interpreted by the Honorable Supreme Court in the fashion that no, the time runs unless the person concerned get knowledge of the award. That is the purpose of that particular benevolent statute is to be, my lord, it is to be interpreted in that way, my lord. My lord, we approach this honorable court, so these are section 14 of the Limitation Act, my lord, this time to
you
be, my lord,
approach this honorable court within time.
within time, and with the time runs within section 14 of the Limitation Act we are praying for, my lord.
Section 14. What does section 14 say? What does section 14 say?
The bona fide approach of the other, my lord, forum.
Before
the other forum, my lord.
No. Before the forum who do not have jurisdiction. Then you mean to say High Court do not have jurisdiction. I shall record your submission and
No, my lord, that is not the thing, my lord.
Section taking the benefit of 14 on the ground that you have approached this. If you say so, I shall record your submission.
No, my lord, I am not.
If you rely upon section 14,
Section 14, section 18, my prayer is that what my learned senior friend has submitted.
You are trying to refer to section 14.
No, I'll deleting that one.
That's it.
That
yes.
part.
Mr. Mondal, what prevented you from making this submission when the matter was moved in 2007 in the earlier writ petition? Why did you not point out this fact? Kindly come to page 73. Affidavit in opposition, paragraph 5. Yes. Subparagraph
8.
Yes. But Mr. Yes, I have seen that. Yes.
Before the draft of the Act 2. So there is no any scope to issue notice under section 3A or 3B in pursuance of the honorable court's order, honorable justice. So there is no any scope. Before lapse of the Act 2, 31st March 1997, award was passed. Thereafter, kindly see the evidence in reply, para S, it is 6. Kindly see the evidence in reply.
Evident reply. Paragraph?
Paragraph ASP, page number page 6.
Yes.
Case C, subparagraph C, subparagraph S and T. And you see, there are S, subparagraph, that the respondent authority paid compensation only for the land and as on 31st March 1997.
Yes.
So it is clear knowledge of the petitioner. The award was passed on the specific period. Thereafter, but not paid any compensation for state 3 and other 3, and also interest for delay payment on compensation money and other compensation as per law. So it is the clear knowledge of the petitioner. Why not file the section 80 within the stipulated period? So the writ petition is the ambiguous. And in spite of that, in pursuance of the Honorable Court's order of Honorable Justice Janto Vista, hearing was also taken.
But why did you not point out? Yes, but because you kept quiet, you are represented. Kindly come to page 73. State was represented in 2007. What prevented you from pointing out this fact that award was passed in 1997?
The LA collector already paid the compensation. Kindly see the evidence in opposition.
No, Mr. Mondal, I appreciate that. Kindly see page 73. This fact was not brought to the notice of the court. Why? In 2007, you ought to have pointed out, no, an award has been passed in 1997. Yes, page 73. Kindly come to page 73 of the writ petition.
After passing the award, any government officer, any state advocate, override the award. Never. Any government officer, any state government advocate cannot override the award.
All these complications arose because this was not pointed out.
Permission of the state not record. In spite of that, the responsible authority already made an arrangement for hearing in pursuance of the court order, and clear says in pursuance of the at the stage of the hearing there is no any scope 9 and 9. So according to the section Act 1, section 12 is not raised at this stage.
No, according to them, no, you have a duty to communicate, to issue a notice under 12(2). According to them, you have not done that.
And page 72 in the evidence in opposition. Award copy, Shankar Kundu and other already received the compensation amount.
This is not the award copy.
Yes, yes,
It's a proceeding
Yes.
apportionment. No.
yes, this is the award copy. Kindly see the page number 73, kindly last page. 85.
Of the writ petition,
Yes, evidence in opposition.
of the affidavit in opposition.
Kindly see page 72.
Page,
Page 70. Papan Kundu, Mohan Kundu.
My lord, we look at the right side column also when the money was paid by check. Right
Yes.
side column. In March 12.
yes.
Yes. Award already 31st March 1997.
Section 11 proceeding for
Yes,
apportionment.
payment
Section 11 proceedings for apportionment.
May I intervene, my lord? My lord, the law is well settled, my lord. The knowledge of passing of an award by
Come back to you. Let Mr. Mondal conclude.
very well.
Yes. Yes, Mr. Mondol.
So please kindly give the earlier para 7 and the policy around one the heavy duty of. Kindly see the para 7 and the heavy duty applies.
Yes.
I said that I had authorized by the and upon the same okay, now to kindly there are 9 and after 9 and 10. And it's R4 and R5. 9 and
Give me a minute. Give me a minute.
the joint security of the government authority. After passing the award on 31st of 90. Kindly sit take
Page of the
position. Next R5.
yes.
The joint security letter. 5.
Yes.
After passing the permission to hold the land,
Excess of the ceiling limit.
permission. So it is not related that the area of the land. According to the land acquisition process. Award for all proceedings will be completed. Award will be completed. Payments will be made to the connection law. I refer one judgment law.
Yes.
After making of award, the claimant can only seek enhanced compensation. Petition seeking restoration of land or Kasansa is not.
So now Mr. Mondal, Mr. Kundu submits that he wants enhancement of compensation under section 18. So according to him, he may be permitted to file a reference application under section 18. What is your reaction to this submission?
The petitioner.
No, he says no notice under section 12(2) was given to him. He came to know sometimes in March 2012. Yes, yes. That can be. Mr. Mondal, with objection, if he accepts, he can make a application for enhancement. There is no difficulty on that. The question is only of limitation. According to him, he came to know sometimes in March 2012 and he has filed the writ petition in May. So within that period of 6 months, he has filed the writ petition and so he may be allowed to file a reference application. He has prayed for that. What is your reaction to this submission?
also said if if pass the award within 6 weeks or 6 months, petitioner has got to file the different case because the condition
Can the court now allow him?
point of that, there was no any application filed before the committee for the collector.
No, Mr. Mondal, yes.
That
Yes, accepted.
petitioner came before this honorable court.
He, according to Mr. Kundu,
Pass the order, issue the notice section 93A 93B. There is no any scope. Act 2. Because within stipulated period, award was passed. So that repetition is a conclusion.
yes.
See my submission and that repetition is not mentioned. Kindly see that kindly see the observation of the
Yes. Which paragraph?
kindly see paragraph 4. The federal largest assistant government appearing for the respondent contended that the state was at no point of time initiated any proceeding for withdrawal of the award path such and such. Kindly see the proceeding finally concluded. Therefore, since the state government has not initiated any proceeding for withdrawal of the award passed under the Land Acquisition Act, the question of restoring the land back to the petitioner does not arise. It is further contended that the notice which is annexed in the petition issued by the rehabilitation officer is undated such and such. Whether there is some notice of tax issued by the authority, even otherwise according to the learned ADP, the notice alleged to have been issued by the rehabilitation officer cannot supersede the order. If at the time of the state authority or state advocate never objection, but he never cannot override the statute.
Yes.
So that institution is not maintainable. Not only that, my lord, the petitioner suo motu, they can arrange for demarcations are there. With their own surveyor. One line they can application according to the commission before the collector for joint measurement, joint verification for demarcations of the land, acquired or non-acquired portions of the land. Till to date, there is no any application filed before the competent authority. So that according to that application is not maintainable. Not only that, in the non-acquired portion of the land, kindly one time one is let them lawsuit directed to the competent petitioner to file the one application for demarcation of the acquired or non-acquired. After 1 year, 2 years, 3 years, 4 years, 50 years, authority can. But till today, there is no any application filed before the competent.
Yes. Anything more? Yes, Mr. Kundu. Anything in reply?
Yes, Lord. Number one, my learned friend has shown a copy of I think an order passed by some of this court, my lord. I do not know. I have not got a copy of the order, which has been relied on by Mr. Mondal. But prior to that, I would like to submit to your lordship. Your lordship takes up the provisions of section 12 first. Section 12. Your lordship, section 12 of the Land Acquisition Act.
Yes.
The notice has to be given by the collector for stating that the award has been passed which shall be final and conclusive between the collector and the persons interested. So, my lord, prior thereto, the question of their stating that the amount has been apportioned, you knew about the award, because your lordship knows, my lord, even after the apportionment, if the award is not passed within a period of 2 years, the award becomes null and void, including all the proceedings thereto. So, my lord, in this case, Mr. Mondal has, even in oral submission before your lordships, had not stated that they have given a notice under section 12(2). So, my lord, as of today, when we have received the copy of the order, the copy of the apportionment, your lordship says he is relying on page 73. Your lordship only takes up page 73 once of the affidavit in opposition. Your lordship only says page 73.
Yes.
Proceedings at the top, third line, fourth line. Form number, first is form number 13A, then land acquisition case number such and such, then proceedings under section 11, Act 1 of 1894. So, my lord, it is, now your lordship will see, what does section 11 say? Your lordship says, what does section 11 say? Section states what inquiry and award of the collector.
Yes.
The award of the collector is not the final award. The final award is only final and conclusive only after notice under section 12 and given to the various persons interested under section 12(2) is concerned. And it is only thereafter section 18 comes into play.
Yes.
So my learned friend has been harping on all these things, section 93A, 93B, without even going through the issue, whether or not they have issued us a notice under section 12(2) or not. So, my lord, his deafening silence is a clear indicator of the point that they have not served a notice under 12(2), even though they were required to do even after the order of the court and also under the act itself.
Yes,
Forget the
Mr.
court
Kuntal
order.
followed. So according to you, since no notice under section 12(2) was served, the limitation did not start to run.
It could not run. And number two, Maharaj, the question which you first of all achieves that if a land which has been subsequently found out to be taken much more than what was acquired, he cannot escape that merely because it's a tea garden, there cannot be. The point is the state government or the central government, whichever may be the acquiring and requiring authority, a person's right, proprietary right in respect of a particular area can only be taken by way of payment of compensation. That is under Article 31A. Now, any land which has been converted into some other road and being run for the benefit of the public, the land user has to repay the compensation. And if I come to court, then what should the court, in my humble submission, do? The court should satisfy its conscience as to whether I am taking the correct thing before a lordship or not. I am making a false case. If I am making a false case, put me to whatever punishment your lordship wants. But if my lordship finds that I have been deprived of not only the land and the compensation of the land which has been acquired, but also of land which has not been paid compensation of. Well, it's well settled, but if land has been taken over, then two things. Your lordship knows the other matter which I have argued for your lordships in that Siliguri Development Authority case. Your lordship permitted us to make an application for payment of compensation of the land which was not acquired but taken possession of.
Yes.
And then file a case under the Fair Resettlement Act of 2013. I am not asking the court to say that whether the compensation of 10 rupees or 100 rupees or 1 crore rupees is correct or incorrect. I am only asking for an access to justice, the justice delivery system, that I may be permitted to have the benefit of the actual amount of land, because I shall not be, the court shall not be, the state shall not be required to pay the rate at today's market price. It will pay at the rate and the rate of acquisition. But even I am being deprived of that also. As of today, with my humble submission, I would say the entire the act itself, the award itself is bad, but I'm not going to go to that extent. I'm only saying, limiting myself to this issue, that notice under section 12(2) was not given to me. Admittedly, in the event a notice under section 12(2) is not been given, it cannot. I have been deprived of filing a notice, a application under section 18. It's a
Yes.
very simple, elementary proposition of law. If Mr. Mondal had come up with to your lordship and say that this is the notice under section 12, you have served, I think he would have just sat down and I had to prove something else.
Yes.
Those are my submissions. Those are my submissions, Your Lordship.
Yes. Yes.
11 and 12 are both together, my lord. Item numbers 11 and 12.
Same thing.
Both are only adjoining land.
Adjoining land,
Yes.
Only the area of land is different. Area of land is different.
but petitioners are same.
You will file by
No.
the
And
Is-
that also, you moved an application before Justice Biswas.
yes, yes.
Same writ petition or different writ petition?
Different writ petition.
Different writ petition. সেটা একটু দেখে নিতে হবে। Item number
12, my lord. Oh.
11 and 12 common order. These writ petitions are taken up for hearing analogously as common questions of fact and law are involved in these writ petitions. First of all, the petitioners claim to be the owners of lands within Mouja is same in both the writ petitions. Claim to be the owners of lands situated at Mouja, Sukhani and Mouja, Sonyastikara. ঠিক আছে? এই page 6 paragraph 2 তে পেয়ে যাবেন। Under police station Raiganj in the Rajganj. Under police station Rajganj na. Rajganj in the district of Jalpaiguri. The lands of the petitioners along with several other plots of land were requisitioned by the collector by an order passed under section 3 of the West Bengal Land within bracket Requisition and Acquisition Act, 1948 within bracket, for short, the 1948 Act. The notice under section 4 within bracket 1 small a bracket closed of the 1948 Act was published by the collector in July 1995, alleging that no step for acquisition of alleging that the collector has not passed an award during the lifetime of the 1948 Act, the petitioners approached this court by filing writ petitions being WP numbers 20744 within bracket W of 2005 and blank. Petition and blank. The said writ petitions came up for hearing on December 12, 2007 before a coordinate bench. Came up for hearing on December 12, 2007, and the coordinate bench disposed of the writ petition by directing the collector to issue requisite notice under section 9 within bracket 3A, 3A bracket capital A, or 3B, as the case may be, of the Land Acquisition Act 1894, for short, the 1894 Act, as was amended by the state government in 1997. The coordinate bench further directed that such notice shall be given to all persons interested, including the petitioners, and after following the provisions of law and giving the petitioners opportunity of participating in the proceedings and presenting their case, within 6 months from the date the notice is issued, the collector shall make and declare the award and pay the compensation to the persons in whose favor the award is made. It was further directed that requisite notice under section 12(2) and section 31 shall be issued to the persons concerned immediately. Thereafter, the petitioner filed this writ petition praying for issuance of a writ of mandamus commanding the respondents to set aside the purported award passed by the respondents on March 31, 1997, and to direct the respondents to issue a notice under section 4 within bracket 1 of the 1894 Act and to pass an award accordingly. The petitioner prayed for an alternative relief in the writ petition, praying for an order permitting the petitioners to file a reference petition under section 18 of the 1894 Act. The petitioners have also prayed for an order directing, prayed for an order for conducting joint measurement of the land of the petitioner, number 1, acquired by the respondents, and to declare an award for the excess land. Full stop. Paragraph. Mr. Kundu, learned advocate appearing for the petitioner, submits that after the order dated December 12, 2007 was passed in the aforesaid writ petitions, comma, no notice under section 9 within bracket 3A bracket closed or 3B was issued. First step, he further submits that no award in terms of section 11 of the 1894 Act was made. First step, he further submits that no notice under section 12 within bracket 2 of the 1894 Act was served upon the petitioners. Full stop. By referring to section 18 of the 1894 Act, Mr. Kundu submits that the collector was under an obligation to serve a notice under section 12(2) as the limitation for filing an application under section 18 of the 1894 Act starts to run with effect from the receipt of such notice. First step, he submits that since no notice under section 12(2) was served upon the petitioners and the petitioner promptly approached this court by filing a writ petition, comma, this court should permit the petitioners to file a reference petition, to approach the court under section 18 of the 1894 Act. Full stop. In Mr. Kundu placed reliance upon a decision of the Honorable Supreme Court in the case of Purushottam Bhai Magan Bhai Patel versus State of Gujarat, reported at 2005 7 SCC 431 in support of his contention that if no notice under section 12(2) of the 1894 Act has been served, the petitioners may be permitted to approach the reference court. Full stop. Paragraph. Mr. Mundo, learned advocate appearing for the state, submits that the award was passed on March 31, 1997. Full stop. He further submits that the petitioners have accepted the compensation amount long back, and therefore the petitioner should not be allowed to, no, should not be permitted to approach the reference court under section 18 of the 1894 Act at this point of time. Full. He further submits that since the award was passed during the lifetime of Act 2 of 1948, Act 2 টা কিন্তু Roman 2 করবেন, এমনি 2 না, Act 2 of 1948, comma, there was no necessity to issue notice under section 9 within bracket 3A or 3B of the land acquisition within bracket West Bengal Amendment bracket closed Act 1997. Stop. Paragraph তার আগে লিখুন, Mr. Mondal placed reliance upon a decision of the Bombay High Court Nagpur bench in the case of Bhakchand Govardhan Nayak versus State of Maharashtra and others, reported at 2005 LAC 361 within bracket Bombay, in support of his contention that with the passing of the award, the proceeding initiated for acquisition of land under the provisions of the Land Acquisition Act stands concluded. Full stop. Paragraph. Heard the learned advocates for the parties and perused the materials placed. Full stop. The state has filed an affidavit in opposition to this application, disclosing the notice issued under section 4 within bracket 1 small a of Act 2 of 1948, which was published in the Calcutta Gazette on July 14, 1995. The in the said affidavit, it has been specifically stated that the award was declared on March 31, 1997. From the documents disclosed in the affidavit in opposition, it appears that the names of the petitioners appear in the list of awardees. Full stop. It is not in dispute that the petitioners have accepted the compensation amount as would be evident from the documents disclosed in the affidavit in opposition. First up, it appears that the petitioners received the compensation amount wide several checks bearing the date of March 26, 2012. Full stop. Mr. Kundu, learned advocate appearing for the petitioner, submits that such compensation amount was received by the petitioners under protest. Full stop. He also submits that immediately after coming to know that the award was passed, the petitioner took steps the petitioner approached the authorities and have received the compensation amount. Full stop. He submits that immediately thereafter, the petitioner approached this court by filing this writ petition, praying for an order permitting the petitioners to approach the court, to approach the reference court under section 18 of the 1894 Act. Full stop. Paragraph. The petitioners have disclosed several notices dated November 18/20, 2009, directing the petitioners to appear at the office of the collector on 25th of November 2009 in connection with the hearing in terms of the order passed in the aforesaid writ petitions. Full stop. Paragraph. It further appears from the documents annexed to the writ petition that the Special Land Acquisition Collector wide memo dated 1/1/2010 informed the petitioners that in connection with case number RA 42/91-92, the lands of the petitioners have been acquired and an award has also been published. Full stop. It further appears from the said notice that the petitioners were requested to collect the compensation amount. Full stop. This court fails to understand as to why the petitioner approached the authorities for receiving the compensation amount only in the month of March 2012. Full stop. After being made aware of the fact that an award was passed, the petitioners ought to have taken prompt steps to take recourses available under the provisions of Act 1 of the provisions of the 1894 Act, more specifically Section 18 thereof. Paragraph. Section 18 of the 1894 Act states that any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the court, whether his objection be to the measurement of the land, the amount of the compensation, the persons to whom it is payable, or the apportionment of the compensation among the persons interested. Subsection 2 of Section 18 states that the application shall state the grounds on which the objection to the award is taken. Proviso to subsection 2 states that every such application shall be made within 6 weeks from the date of the collector's award, if the person making it was present or represented before the collector at the time when he has made the award, and in other cases, within 6 weeks of the receipt of the notice from the collector under section 12, subsection 2 bracketer moddhe, or within 6 months from the date of the collector's award, whichever period shall first expire. This court finds from the documents disclosed in the writ petition that the petitioner was served with a notice by memo dated 1/1/2010 informing them that the award has been made, and with a request to them to collect the compensation amount. The petitioner has not disclosed the reasons as to why the petitioner approached the authorities for receiving the compensation amount only in the month of March 2012, or could not file the application under section 18 of the the reasons for which the petitioner did not approach the reference court under section 18 of the 1894 Act is best known to the petitioners. In Purushottam Bhai Magan Bhai Patel, Supra, the Honorable Supreme Court, after noting that the in Purushottam Bhai Maganlal Patel, Supra, the petitioners therein filed an application under section 18 of the 1894 Act, and on the facts of that case, the Honorable Supreme Court held that such application was well within the period of limitation. The said decision, being distinguishable on facts, cannot come to the aid of the petitioner in the case on hand. First up, therefore, this court is not inclined to grant any liberty to the petitioner to approach the reference court under section 18 of the 1894 Act. The paragraph. Insofar as the prayer of the petitioner for joint measurement of the land in question is concerned, this court finds that the petitioner has not stated specifically as to the amount of land which has been utilized in excess of the land which was initially requisitioned and subsequently acquired under the provisions by invoking the provisions of Act 2, Roman 2 of 1948. It is well settled that the court cannot be used as a tool to make a roving inquiry. Full stop. For such reason, this court is not inclined to allow the prayer for joint measurement. Full stop. For all the reasons as aforesaid, the writ petition, joint measurement of the lands in question. Full stop. For all the reasons as aforesaid, the writ petition stands dismissed. There shall be, however, no order as to costs. Urgent photostat certified copy.
Or one inline is
তার আগে লিখে দিন এইটার আগে লাস্ট ওই যেখানটা বললাম না ওই আরেকটা জাজমেন্ট যেখানে বললাম একটা বলেছি সেইখানে সেইখানে আরেকটা তারপরে প্যারাগ্রাফে একটা লিখুন যে there is no quarrel to the proposition of law laid down in Bhakchand Govardhan Nayak Supra that upon making an award, the proceedings initiated for acquisition of land under the provisions of Land Acquisition Act stands concluded.
May I prefer one intelligence so that the joint measurement I can approach to the authority, but that right is there.
That
one
always have
line,
no liberty that will
one
give
line-
rise to another.
one line may, my lord, that will may
liberty.
expedite the proceedings. My
No
lord.
liberty you have not yet applied. No liberty is necessary. You have already, you can approach. But you cannot use the court as a tool for that. That is the observation. Yes, first matter you are not there. You are there in both the matters. ওই ওনার এই একটা লাইন লিখে দেবেন ওনার ইন দি সেকেন্ড which item second matter তো ফার্স্ট ম্যাটারটাতে না দুটো appointment of Mr. such and such be regularized in WPA ওই প্রথমটা WPA 12332 of 2012. Let the appointment be regularized by the legal remembrancer. বড়টাতে তো ওনাদের অ্যাপয়েন্টমেন্ট ঠিক রেগুলারাইজ হয়, শুধু 11টাতে ওই একটা না হলে আবার মুশকিল হয়ে যাবে যেখানে। Yes, call the next matter.
54.
54, yes.
Lord, I already started, my Lord, my arguments on the last occasion.
Time when
Not
you are
be-
starting at the fag end.
My Lord, just to recapitulate the facts, Your Lordship.
Yes.
Lord, I have been given punishment of compulsory retirement by the appellate authority, followed by a disciplinary proceeding, my Lord. Lord, on the last date, I have placed the charge sheet, my Lord, and the complaints on which the charge sheet has been drawn up. Now, my Lord, the first point that have been taken, my Lord, that the complaint on the basis of which the charge sheet has been drawn up, my Lord, there has been certain words specific. Lord, the charge in sum and substance is that I have used some specific abusive language to a junior fellow and thereafter I have beaten him. When he has come to me with a complaint regarding something family in nature of family dispute. Now, my Lord, the specific words that has been taken place or part of the charge sheet, those were missing in the complaint. My Lord, may I again, Your Lordship, take
So according to you, that charge is without any basis.
My Lord,
Charge is without any basis
Lordship,
because the complaint did not say so.
Lordship.
Yes.
My Lord, may I just place the, my Lord, copy of those.
What are the points on which you will be arguing?
My Lord, first is biasness, Your Lordship, then perversity.
What is the perversity?
My Lord, may I just first
Yes.
place those documents and then I'll come to the legal points, my Lord.
Yes.
My Lord, first kindly come to page 33. That is the charge-
33. Yes.
That is the charge sheet. My Lord, the charges are at page 36. Relevant portion is at 36.
Yes.
That force number, my Lord has got it, my Lord. That force number such and such, Sushanta Kumar Bokshi, 3 Signal Battalion CRPF while working as a SI administration on 1st of March 2020 in front of 3 Signal Battalion at about 1 hour as a member under section 11(1) of Central Reserve Police Force Act 1949, disobeyed the order, ignored his duties, showed negligence in the discharge of his duty and misconducted, in which he abused member of the force, Constable Godachand Shamui, junior to him, with such and such abusive language, my Lord has seen those, and landed blow on him, as a result of which he had injury on his eyes, nose, and lips. This act of the personnel is a serious and punishable offense under section 11(1) of the CRPF Act 1949, read with the rule 27 of CRPF rules. Now, my Lord, will find at page 38, my Lord,
Yes.
list of documents. Item of charges against force number such and such, Sushanta Kumar Bokshi. My Lord, first is letter of complaint dated 4th March 2020.
So according to you, in these 2 complaint letters, those words were not
No,
said.
my Lord, first point is, my Lord, this incident happened on 1st of March 2020. The complaint is of 4th of March 2020. So, my Lord, it cannot be said that in hurry they could not remember things and they have given a complaint. They had enough time to think and thereafter they have given a complaint, I believe.
Yes.
Now, my Lord, then the medical documents and, my Lord, photograph and any other necessary. Now, my Lord, kindly comes to page, my Lord, 173.
Yes.
This is the complaint of the wife. Lord, regarding appetizing, my lord, kindly excuse the English because it was in Hindi language and thereafter has been
It has been
translated.
translated.
Lordship.
All right.
Indecent behavior and application of complaint regarding the same that respected sir, I Shaboni Shamui, wife of GC Shamui, constable such and such. I live in quarter number 69, type 1 on 1st of March 2020 for the dance class club of my daughter or admission of my daughter in the dance class. I went to men's club. However, the dance class was being held in the recreation room. I asked the in charge named Shumon Kumar. He forbade me. However, upon request, I stayed there. During that time, Shumon Kumar outraged my modesty, which I cannot describe here. I told my husband about the same, who had gone to the market. After he came back, he started quarreling with me and my husband. Then J. Sahib S.K. Bukshi reached there. My lord kindly says J. Sahib reached there.
Yes.
J. Sahib, instead of any settlement or persuasion, assaulted my husband and entire into scaffolding. My husband got injured and he got himself treated in BSF hospital. I am carrying now, and under this situation, my health is deteriorating because of this. I pray to you with folded hand that kindly justice be made out to me. I shall remain ever grateful. This is the wife's complaint. Now, my lord, kindly sees the husband's complaint, which is at page 175. This is submit that I, Constable Godachand Shamui, that on 1st of March 2020, my wife.
Yes, I've seen this.
My lord has seen this, but there's no utterance of the specific
Yes.
words that has been used. So, my lord, how can the disciplinary authority, my lord, drawing up the chart sheet, come up with this specific abusive language, which has magically taken part of the deposition? My lord, at the time of deposition, these two these two complainants, they are saying the same words, which the disciplinary authority has put in the chart sheet. That is one. Now, my lord, may I take your lordship to the reply of the chart sheet, to my reply.
But what do you have to say with regard to the injuries that have been suffered?
My lord, I will show you lordship. There's a dispute.
What is your stand with regard to those injuries?
Lordship? My lord, I am not saying that nothing has happened on that particular day. My lord, my allegation is that he was intoxicated at that point of time. My lord, what happened? I was already discharging a duty for the honorable governor. At that point of time, he came to me with certain disputes and allegations, and along with him, this Sunil Kumar Shuman, who is another junior fellow, he has also come. Now, my lord, since I was already, my lord, given a duty for the honorable governor, I asked him that you come later. He, my lord, started abusing me and saying different abusive language. My lord, my lord, first raised his hands on me. My lord, I have also then, my lord, reacted to that. That's how this has taken place. Now, my lord, what he has done, he
So
has
have you
altered
taken the
and
plea
twisted
that
story.
whatever you have done, that was in self-defense?
Lordship, may I,
That was your statement.
lordship,
Yes.
my lord, may kindly come to page 40.
40.
Lordship. This is to humbly submit. My lord has got it, my lord. May I trace it, my lord?
All right. আসুন। heard the learned advocate for the petitioner. First up. List this matter. Tomorrow,
My lord, day after tomorrow.
uh,
Tomorrow I have some difficulty, my lord.
5th,
Fifth.
list this matter on 5th of December 2024 under the heading fixed matter.
Lord. Lord, I'm led by Mr. Shoma Majumdar.
He has come to court.
Lord.
Lord, before rising, my lord, only one prayer.
Mr. মজুমদারের নামটা এক করে দিন। হ্যাঁ
Lord, before,
মিস্টার মজুমদারের নামটা উপরে দিয়ে দিন, কিন্তু এখানে লিখবেন হার্ড মিস ঘোষ লার্নের অ্যাডভোকেট ফর দ্য পিটিশন।
Lord, before rising, may I have your lordship's kind attention to mention a matter, your lordship. This for in the list of Lord, should matter must come under the heading, Lord, hearing. The affidavits are completed, my lord.
Which item?
Lord, the matter is not running in your list, my lord. I am mentioning upon notice, my lord, upon the other side. Lord,
Mentioning not now. I have taken some of the mentioning slips. Let me dispose of few matters. Thereafter, I will go.
my lord, these are, my lord, only one thing. Lord, these are matter, my lord, where senior citizens are involved, my lord. Disciplinary proceeding was done, my lord, and 10 lakh rupees has been deducted from the retiral dues, my lord. It is pending since 2022, your lordship. Kindly the matter be included in the list, my lord, as and when your
Wait
lordship.
for some time. Let me dispose of. No use unnecessarily making the list lengthy. Let me dispose of some matters. Thereafter, I will again.
Lord, this is an urgent matter, my lord. Matter could not be heard since 2020.
Urgent, move before the regular bench.